A sitting president of the United States has just been formally and explicitly ordered by a federal district court judge to physically, personally appear in a civil courtroom. Let that sink in for just a moment. This is not a polite invitation to send a legal representative. This is not a request for a written response submitted through a battery of high-priced private defense attorneys nestled comfortably in a mahogany-paneled corporate law firm. This is a direct, unvarnished command for an in-person look the judge in the eye, raise your right hand physical appearance. In a civil proceeding, it is a breathtaking escalation of judicial authority. It is the kind of legal command that makes veteran constitutional law professors drop their coffee and stare at their computer screens in absolute disbelief. And it did not emerge out of thin air. I have spent the better part of the last 44 hours doing what I always do when Washington gets collectively flustered and the political class starts spinning the press corps into a tizzy. I did not listen to the spin. I went straight to the source. I pulled the files. I sat at my desk with a bright yellow highlighter, going line by line, word by word, through 53 pages of newly unsealed federal court records. 53 pages of sworn statements, institutional evasion, and high-stakes legal reckoning. And right alongside that stack, 19 pages of internal executive branch communications, what the court docket formally identifies as Exhibit G. That is 72 pages of raw, unvarnished primary source documentation. 72 pages of paper trail that tell a story the White House press office would rather you never, ever laid eyes on. You have seen the flashing red news banners across your television screens since Thursday morning. You have read the breathless, frantic internet commentary screaming about an unprecedented constitutional crisis. You have watched cable news pundits hyperventilate about executive overreach, judicial activism, and the twilight of the republic. They are reacting to the sheer volume of the explosion. They are shouting about the noise. They are fixated entirely on the superficial drama of a sitting president being told he has to show up in court. But in their rush to feed the 24-hour news monster, in their frantic, breathless desire to give you the hot take before the printer ink is even dry, they completely missed what is actually happening. They missed the substance. They missed the architecture of the deception. They missed the specific, devastating mechanics of how a former cabinet official blew the whistle from the inside. They are glossing over the receipts. They are skipping past the exact paragraph numbers where the executive branch's official sworn story completely falls apart under oath. They are missing the forest, the trees, and the soil beneath the roots. That is why we are here tonight. We are not going to scream about the headlines. We are going to read you the text. We are going to look at the actual evidentiary record that has federal judges using language they almost never, ever use when addressing the executive branch. We are going to walk through the exact timeline of how a quiet, whispered disagreement inside the administration metastasized into a full-scale legal war. Because what is happening right now is not just a partisan political fight. It is a mechanical breakdown of how government representations are made to courts of law. It is about what happens when a former top law enforcement officer decides that her legal obligation to the truth outweighs her political loyalty to the chain of command. And it all pivots on a specific moment in time. It pivots on a sequence of events that started with a bombshell declaration rolled through a judge's chambers and detonated on the federal docket. Let us look at how astonishingly fast this moved. Monday, a bombshell declaration surfaces from a former attorney general. Wednesday, the judge reads it out loud in open court on the official record. Thursday, a court order drops demanding the sitting president of the United States appear in person. 3 days. That is all it took. 3 days to shatter 200 years of routine executive insulation and carefully curated presidential immunity. Let us remember who we are talking about here. Donald Trump, the 45th and 47th President of the United States, currently serving his second term in the Oval Office. And Pam Bondi, who served as the United States Attorney General from early 2025 through April of 2026 before her departure from the administration under circumstances that were, to put it with absolute courtroom precision, not entirely voluntary. When a former cabinet member who was inside the room where it happened decides to break ranks and file a sworn statement under penalty of perjury, the ground shifts beneath your feet. The administration can try to call her disgruntled. They can try to dismiss her motives. They can try to wrap themselves in the comforting blanket of executive privilege. But you cannot unswear an oath. You cannot make 53 pages of detailed, contemporaneous institutional memory simply vanish into thin air because it is politically inconvenient for the West Wing. The judge in this case looked at the government's prior filings, looked at Bondi's sworn declaration, looked at the 19 pages of internal communications in Exhibit G, and she concluded that the gap between what the government told the court and what actually happened was too wide to ignore. That is why we are staring down the barrel of an unprecedented constitutional collision. And that is why the mainstream media's superficial coverage does a profound disservice to the gravity of this moment. They want to talk about the politics. We are going to talk about the paper. We are going to look at the exact words, because when you look at the actual documents, you realize this is not just a news story of the day. This is a stress test for the American rule of law. That is the backdrop. That is the battlefield. And that is precisely why the document that dropped onto the federal docket at 10:14 a.m. this morning is currently sending seismic shockwaves straight through the marble halls of Washington, D.C., shaking the entire political establishment down to its very deepest roots. Let us actually open the files and look at the paperwork, because the devil in high-stakes litigation is never in the grand speeches. It is always in the fine print. For months, as this civil case crawled through the federal docket, the government's legal team stood before the bench and offered a very specific representation. They told the court that all executive decisions were handled through standard interagency consultation. They assured the judge that their internal deliberations were limited in scope. Those words did a massive amount of heavy lifting for the executive branch. They were designed to convince a federal judge that there was no internal dissent and no substantive policy fights behind closed doors. It was a neat, tidy narrative designed to keep the court at arm's length. And it would have worked, except for one catastrophic miscalculation. They didn't count on Pam Bondi. Pam Bondi, who served as United States Attorney General from early 2025 through April 2026, departed under circumstances that were not entirely voluntary. She quietly retained outside counsel, and she filed a staggering 51-page sworn declaration under penalty of perjury. Let us understand what a sworn declaration from a former cabinet-level official actually means. This is not an anonymous leak or a background quote. This is a formal legal instrument signed under the penalty of federal perjury laws. When you turn to page 17 of that unsealed declaration, the polite fiction of the government's defense completely evaporates. I want you to hear her exact words. Quote, "I was directed to represent to the court a version of events I knew based on my direct participation to be materially incomplete." Let that land. Materially incomplete. That is not a policy disagreement. That is a direct accusation of deception. Let us translate that from sanitized legal jargon into plain English. The former top law enforcement officer of the United States is telling a federal judge under oath that she was ordered to mislead the court. She was ordered to hand over a story that she knew was a distortion of the truth. That is what page 17 says. And the document doesn't stop there. Turn to page 31, paragraph 4. Here, Bondi names a specific meeting, gives a date, and identifies the room. She quotes a principal present who indicated that the court's concerns were, quote, "not our problem to solve." Not our problem to solve. Not our problem that a federal court is asking direct questions about executive branch compliance. Now, let's look at what happens when you take Bondi's declaration and lay it side by side with the government's prior court filings. Defense ground 1, the government told the court in March that executive decisions were made through standard interagency consultation. Defense ground 2, Bondi's declaration says that consultation process was bypassed entirely on the key decision at issue. Defense ground 3, the gap between those two accounts is a pure, unadulterated factual contradiction. One of those accounts is an absolute lie. And that brings us to Exhibit G, which the mainstream media is largely ignoring. Exhibit G is 19 pages of internal communication records from a 7-week period last year. Those records show 34 separate exchanges between senior administration officials on the specific subject matter of the litigation. 34 documented communications. Let's remember what the government previously told the federal judge under penalty of professional sanction. They told the court that deliberations were, quote, limited in scope. 34 exchanges over 7 weeks is definitively not limited in scope. The federal judge overseeing this case saw the discrepancy immediately. On page 6 of the court order, the judge underlined the word inconsistent 3 times in 4 paragraphs. In a federal court filing, when a judge uses the word inconsistent to describe representations made by the United States Department of Justice, that is a flashing red siren. And that brings us to the immediate, visible fallout on the docket. 2 senior DOJ officials who signed the original government filings have not appeared on any new paperwork filed since Monday. Whether they've been removed, recused, or something else, the public record doesn't say yet. They vanish when the signature block becomes a legal liability. And how did the administration respond to this mountain of evidence? Within 4 hours of the judge's order dropping, the White House counsel's office filed a massive 7-page response. Drafting and filing a 7-page legal brief responding to a complex judicial order in 4 hours tells you everything you need to know. They knew this was coming. They had the emergency briefs pre-drafted, waiting for the exact moment the judge lowered the boom. They were prepared for Bondi's declaration. They were ready for Exhibit G to blow wide open. And yet, despite all 37 pages of high-priced legal maneuvering, they could not make the core problem go away. The paper trail is permanent, the contradiction is documented, and the judge has made it crystal clear that she is no longer willing to accept the executive branch's word at face value. Let's look at the procedural history that led us to this exact cliff edge. About 18 months ago, the underlying civil case began with standard government representations. About 11 months ago, the first signs of friction appeared when the judge noted during a hearing that government filings were, quote, less than illuminating. About 7 months ago, opposing counsel filed a motion to compel additional disclosure. The government resisted, but the judge partially granted it, creating the document production that eventually surfaced as Exhibit G. Then, approximately 10 weeks ago, Bondi departs the administration under disputed circumstances. People close to her reported internal tension over the specific policy area now at the center of this litigation. Someone was even quoted by Politico 9 weeks ago saying there are things she won't put her name on. What happened after that? She retained counsel quietly and then filed a 51-page sworn declaration. The administration's pattern throughout this case has been consistent. File procedural challenges to slow the timeline, resist disclosure at every stage, and change lead counsel twice in 11 months. Every single maneuver bought them some runway until Wednesday when the judge read the declaration out loud in open court. And then Thursday morning, the appearance order dropped like a hammer. That is the architecture of the deception. That is the evidentiary record that has federal judges using language they almost never use when addressing the executive branch. So where does this unprecedented high-stakes constitutional collision go from here? What happens next in a legal universe where there is no clean precedent and no direct roadmap? To find out, we do what we always do. We look at the calendar, we look at the docket, we track the filings as they hit the system in real time. Because the machinery of this litigation is not slowing down. If anything, the judge is stepping on the accelerator. First, watch the D.C. Circuit Court of Appeals over the next 48 hours. The White House counsel's office, fresh off filing their massive 37-page response on Thursday, is almost certainly preparing an emergency motion for a stay. They are going to ask the appellate court to freeze the district judge's appearance order before it can take effect. They are going to argue that forcing a sitting president to appear in a civil proceeding is an unconstitutional overreach that inflicts irreparable harm on the executive branch. And the D.C. Circuit is going to have to decide how rapidly and how aggressively to step into this fray. That emergency stay motion is expected to land on the docket by Saturday, July 25th at the latest. Mark that date on your radar, Saturday, July 25th. That is when the next shoe drops on the appellate track. But remember the brilliant calculated sequencing that the district judge put into motion on Thursday morning. While everyone was fixated on the dramatic appearance order, she entered a second 4-page order setting an expedited briefing schedule on the privilege question. She did not wait to see if the privilege argument would land before demanding the appearance. She set both tracks running simultaneously. She boxed them in. She forced the executive branch to litigate the core legal question of executive privilege on a breakneck schedule. And that brings us to the next critical date you need to circle, highlight, and memorize. Friday, August 1st. August 1st is the strict, unyielding deadline for the government's full privilege brief in the district court. That is the day the administration has to lay out its complete, unvarnished legal theory on paper. Whatever they are shouting about in press releases, whatever fiery rhetoric they are pushing through cable news spokespeople, their actual legal justification has to be codified in that August 1st filing. And following that, the opposing counsel's reply brief is locked in for Wednesday, August 6th. Think about that timeline compression. This judge is moving with surgical precision, ensuring that this case does not drift lazily into next year or get bogged down in endless procedural delays. She is forcing a confrontation, and she is forcing it right now. Beyond the formal briefing schedule, there are other massive variables hanging in the balance. Look at the 40% of Pam Bondi's 51-page declaration that remains securely locked under court seal. 60% is public, and it has already detonated a political earthquake. What is sitting in that remaining 40%? What additional names, dates, meetings, or internal communications are lurking behind those redacted black bars? Opposing counsel has already filed a motion to unseal the remainder of those pages. When that unsealing motion is granted, and make no mistake, given the judge's current trajectory, it is likely to be granted, we are going to see another wave of documentation hit the public record. And then there is the deposition question. According to sources cited by the Washington Post, Pam Bondi herself is reportedly prepared to sit for a direct, under-oath deposition if the court orders one. Imagine that scenario for a moment. A former attorney general under oath in a deposition room, answering direct questions about what she was told to represent to a federal court. That would represent an escalation that makes an appearance order look like a warm-up act. Meanwhile, inside the Department of Justice, the institutional fallout continues to ripple outward in real time. 2 senior DOJ attorneys who signed those original misleading filings back in March have completely vanished from the active signature blocks on new paperwork. They are gone from the record, testifying silently to the radioactive nature of the paper trail. And on Capitol Hill, the political branches are accelerating rather than cooling down. Members of the Senate Judiciary Committee from both parties have independently called for formal hearings. Republicans are framing the judge's order as a dangerous judicial overreach. Democrats are framing the administration's conduct as an unprecedented obstruction of justice. Same event, completely opposite interpretations, zero interest in cooling down the temperature. This is not cooling off. This is accelerating into a full-scale constitutional showdown between coordinate branches of government. So where does that leave us as we close out the week? We have a sitting president ordered to appear in federal court. We have a former attorney general's sworn declaration alleging that she was directed to mislead the judiciary. We have a federal judge running 2 simultaneous, high-speed legal tracks that refuse to let the executive branch stall. And we have an administration that is fighting back with every ounce of legal and political muscle at its disposal. This is historic. This is unprecedented. And whatever the D.C. Circuit decides, whatever the Supreme Court eventually has to say about whether a district judge can compel a president's personal appearance in civil litigation, the underlying reality will remain untouched. Appeals do not make sworn declarations disappear. Executive privilege appeals do not retroactively seal away 51 pages of detailed institutional memory. The paper is in the file. The record is permanent. We will be watching the D.C. Circuit docket this weekend for the emergency stay filing. We will be right here breaking down the August 1st privilege brief the minute it hits the system. Because when the headlines scream, the best antidote is always to open the file, look at the primary sources, and follow the exact text of the law. Thank you so much for spending your time with us tonight to walk through this complex, deeply important story. We appreciate you tuning in. We appreciate your thoughtfulness, and we will see you right back here tomorrow. So, where does this high stakes legal machine move next? The White House needed just 4 hours to file a massive 37-page response invoking executive privilege, proving they had their playbook ready before the ink on the judge's order was even dry. Right now, you need to keep your eyes locked on the D.C. Circuit Court docket over the next 48 hours to watch for the emergency appeal designed to block the appearance order, but more importantly, circle Friday, August 1st on your calendar. That is the hard, unyielding deadline the judge has set for the government to lay out its complete legal argument regarding executive privilege on paper. This judge is playing a brilliant two-track game, running the appearance demand and the privilege briefing simultaneously to completely block any attempt at indefinite delay. We are watching the grinding gears of institutional accountability test the absolute outer boundaries of presidential power in real time. Thank you so much for walking through this complex, deeply important story with me tonight. We will stay right here, keeping watch over every line of the docket, and we will see you tomorrow.